court presentment. The city, state, or county has just honored you with a court presentment. It is a verified complaint, or grand jury indictment, or traffic ticket. Do you feel honored? No? Why not? Do you feel fear, anger, confidence that you can defend your position? Let's analyze this situation. The state is used in this writing generically as a general term representing any corporate quasi-government organization and its agencies. You is used in this writing to represent the reader, the living soul. Straw man is used in this writing to represent an individual United States citizen. What is this presentment? What are its components? It has your name on it. It does not have your name on it. It has the straw man's name on it. The moving party has named a straw man as a violator of a statute and has asked you to take responsibility for the violation. The state, city, and county, or IRS, cannot file a claim against you. It is charging the straw man with a violation. Stop. It is establishing a value through an index associated with statute violations. This is ingenious. If you honor the presenter with an acceptance and return, the index establishes the amount of credit you will provide to the state. If you dishonor, the index establishes the amount of property the state will take to get the credits it needs. The presumption is that you are in partnership with the straw man. In some cases, the index establishes how many months you'll be in jail while they collect your credits, holding your body for a breach of fiduciary duty. Since you agreed to be the trustee, everyone in jail agreed to be the trustee. Don't agree to be the trustee. Only the trustee can go to jail. Only the all caps can go to jail. It suggests a time period for you to answer. Stop. Don't trust this one. It establishes a time period for the straw man to answer on the public side, usually 20 days, probably just long enough to get you in dishonor. Bam. Actually, yes, if you don't accept it in 72 hours from the private side, you will be in dishonor. And that goes for them too. When you present your bond to them, now they have 72 hours, or they're going to be in dishonor. See how it works? You're offering payment. They better accept it. They have no choice. The presentment is designed to help you into a dishonor. You don't have to go out that way, if you don't want to. That's up to you. You got to pick your battles. For research purposes only. It has the name of the party bringing the claim. Someone has to approach you to ask you for your help. That person is taking a big chance. By signing his name, he could end up owing the amount of money that the state is asking you to pay. This is usually an attorney. He signs his name to it and becomes the attorney of record for the plaintiff. The state, through an attorney or other officer, has given you a court presentment, a request for your help. Options: defend it, argue about it, conditionally accept it, ignore it, or just accept it. You already know the right choice. You only have one good choice. It only makes sense if you want to take responsibility for a matter. If you're the type of person that sees fit to do so, then you only have one good choice, is to accept it. If you defend it, you are refusing to take responsibility for managing the affairs of your business, the United States, and their bankruptcy. Be a good patriot. Whether you want to admit it or not, the United States is your creation. It continues in business because you authorized it. If you argue, you are in controversy with your own business managers. If you conditionally accept, you are requiring the United States to prove it has a claim when it's in receivership and it cannot have a valid claim against you without your permission. If you ignore the presentment, you're acting like an irresponsible creditor, and you will lose your status as creditor. Your only choice is to accept. Doesn't matter what it is. That by itself is not enough, though. If you accept it and return it, you have not carried out the promise you made when you accepted it. It's like signing the requisition form but not instructing anyone to write the check. You have accepted the presentment, the charges, but you have not given them what they need, your credit. It is like promising to pay the electric bill but never getting around to it. If you do this, they will turn off the electricity. Now, when you accept the presentment for value, you have to follow through with some type of instrument. If you do not authorize the state to use your credit to settle the account after you have accepted, you are in dishonor. If you do not authorize the attorney to use your credit to settle the court account after you have accepted, you are in dishonor. The state and the attorney will use your dishonor to charge their agents with authority to take the strawman's property and your body. Either way, the state and the court will get the use of your credit. The United States and its states are in receivership, so they have no credit of their own. They need your credit, and they will get it. The corporate counties and the cities are in this dysfunctional situation. They all need your credit. When they ask for it, give it to them. Follow through with your promise of acceptance and give them the use of your credit to cover the bond, the charges. Be the creditor you can be. Take responsibility. Court remedy. The presentment is like a check. Okay? When they send you that complaint, that's like a check. Turn it over and sign it on the back. It is accept and return the court presentment. Okay? Sent to you with a request for some kind of... is there an assessed value on the presentment? If there is, you endorse it and return it, accepted for assessed value, and returned in exchange. In exchange for that, then they will know you have approved the use of your credit for closure and settlement of this accounting. It got a little jumbled here in the with the Internet Archive and their presentation of the material, but if there is no assessed value on the presentment, use offsetting credit. They just need your accepted for value and returned in exchange, authorizing signature, foreclosure and settlement of this accounting to get the credit to enter onto the books. Remember, there is no money. Attach an asset, an authorization for the state to use your credit, a credit authorization. A bill of exchange is one of the instruments you can use to authorize the use of your credit. Go look at, there's an international bill of exchange. Use that as a template from the internet. The United Nations has an international bill of exchange format that you can utilize to make sure that all of the essential terms and issues are in there. It settles the immediate charge requisition. It needs a date, an account number, a value, the name of the person who is to receive the credits, the name of the public creditor, the Secretary of the Treasury, the name of the public pass-through, your straw man, instructions. Instructions are very important. There must be a letter of instruction or an instructions portion of your communication. An instruction number. Your name, the private creditor, your exemption number, the creditor ID number, your signature. This is the endorsement. Don't forget the signature endorsement. You can put your thumbprint there if you wish. Don't forget your postage stamps. Instructions are very important. Non-cash items require instructions. If you do not understand them, don't send them with your instrument. or do anything else until you understand what you are doing. Using other people's paperwork can be very detrimental to your success. Keep the instructions in plain English. These instructions are a great topic for discussion with your study groups. This is where the Treasury Tax and Loan Department, the TT&L, of the bank is incorporated into the process, and where the electronic fund transfer instructions are found. Be careful about putting information in boxes. It doesn't appear if it's in a box, and it doesn't appear on the document. Clerical information can be in boxes, but keep the substantial information outside the boxes. It is absolutely imperative that you understand there is nothing that is going to be transferred from the United States Treasury to the holder's bank. There is no funds transfer, there's no money transfer, there's no credit transfer. The money's not going to fly over there. The credits are in your instrument with your signature on it, with a dollar sign followed by digits greater than 0. When it is endorsed by the recipient and delivered to its bank, the credits are already there. They just need the account number to go put them there that's intended to receive them, and the use of the exemption needs to be approved by the Secretary of the Treasury. Such approval is done through the TT&L department at a bank where the instrument is delivered. The electronic transfer is not a transfer of money, credit, or funds. It is a transfer of digital information from the Federal Reserve Bank through the federal window to the Treasury, where it can be approved or refused by the one who currently holds the office of Secretary of the Treasury of the United States. This is Tim Geithner at the time. He is also the one who keeps track of the national debt, which is partially owed to the people of the American states, who have funded the United States with their credit since 1933. He is the trustee on the Chapter 11 bankruptcy of the United States. All bookkeeping in the United States is done through him. When you use your exemption, the national debt is reduced in equal proportion. Did you hear that? I'm not going to repeat myself like other people do. I think that's ridiculous. Timothy Geithner, Secretary of the Treasury, has to keep track of the debts and the credits on the national debt. You cannot leave him out of the equation. Just hit him with a notice. Letter of credit. When you authorize the use of your credit, you must arrange for that credit to be approved by a third party in public, the Timothy Geithner, the Secretary of the Treasury, when the presenter processes your instrument. If you don't do this, it's like writing a check on an open bank account that has no balance or insufficient funds. The private side, when you use our exemption to bond your acceptance of a presentment, the public auditor must receive notice of your intent. Again, the Timothy Geithner. The United States is not bankrupt, it's just in receivership. It can't make valid claims without an existing debt. So it can get your credit anyway, the choice is yours. When the presentment is delivered into your hands, you become the holder. The state has honored you with presentment because you are in a position to help the state out. When you endorse it as a holder, you are assigning the property, interest in some associated substance, your credit, related to the presentment to someone else. If the presentment is signed by Jim Black, it should be returned to Jim Black. If the signature on the presentment is only a logo and there is no other signature, the presentment should be returned to the name and address on the logo or letterhead. In that case, no man has accepted the commercial liability for the presentment. That does not really matter. You are not doing a conditional acceptance. You are doing an all-out acceptance. So you don't care about anyone else's liability because you are agreeing to be fully responsible. Boom. Get the matter resolved. And move on with your life. United States and all its officers, agents, employees had no commercial capacity to really make claims without evidence of an existing debt. That does not mean that the state will not make it look like it is making claims. It needs your credit. So it is going to go through the motions of making claims. Do not embarrass the agents and point out that it has no commercial energy. Don't tell the judge it's just all a bunch of horse shit and nonsense. Okay? It is your job to use your commercial capacity to fulfill the requisition without making it too obvious to the public. You're not allowed to upset the people. You are coming in from the private side quietly to provide your credit for the public's use. Don't make a big deal out of it. Most of the public do not know the state has no commercial capacity to bring claims. Keep your knowledge to yourself. The public is not ready for full disclosure of this yet. Be tactful. Be discreet. Don't get upset. Don't get angry. There's nothing to get angry or upset about. It's just business. It's not personal. Be relaxed and calm and just handle your business with it. Be soft-spoken. Speak right to the judge. Call him judge. Don't call him your honor. Recap. Private administrative process. The notary sent your notice of acceptance with your acceptance and return. 2. The notary sent a notice of non-response or notice of breach if there is a contract involved. 3. The notary issued a certificate of non-response or certificate of breach to you. Bam. Super powerful. The certificate establishes that you accepted and returned and exchanged your exemption for a discharge, that your acceptance was received and accepted by the respondent twice, that the respondent refused to respond or comply with your request, that there is an agreement of the parties, that the respondent has no commercial energy to pursue collection, that you have all the commercial energy regarding the subject matter, that you are in honor, that the respondent is in dishonor. See, this is how you enforce your paperwork. You have to learn how to enforce everything in this life. No one is ever going to do what they're supposed to do, even if the law compels them to do so. You have to know how to enforce everything in this life, or learn how. It's a learning process. But you're going to have to learn how to enforce everything, because no one's ever going to do what they're supposed to do unless it's being enforced. And that's just the way it is. So understand that right now. You're going to have to always go that extra step. Just because you did all your paperwork right, that you still have to know how to enforce it. And that's the only way to get someone to do what they're supposed to do. Now, court process. Some of it's private and some of it's public. 1. Accept for value and return the court presentment to the signing attorney. 2. Attach a credit authorization with instructions for the attorney to use to settle the court accounting. 3. Send a letter of credit to the Treasury. 4. Get a certified copy of the judge's oath and accept it for value. 5. Get a certified copy of the judge's bond and accept it for value. 6. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge. 7. Keep or file a notice of acceptance on the public side. 8. Get a copy of the court order appointing the attorney and accept it for value. 9. Prepare a letter of instructions to be mailed to the appointed defense attorney and to request bond. 10. Check the clerk's file for a bond. 11. Prepare your bond and bond the case. 12. Remove the case to another court, if necessary, for judicial review of your administrative process. What you've done on the private side has not appeared on the public side yet. Remember rule number 1. If you don't let the public know what you're doing on the private side, it will appear as if you're ignoring the presentment, and that will result in a default judgment due to your dishonor of the state's presentment. Get a certified copy of the judge's oath of office if you can, and accept it for value. That is evidence of the man's contract with the people. That's you on the private side. You want him to take judicial notice of his contract with you. You could just let him know that you accept his oath when you're in the courtroom with him. First, you have to ask him if he's on his oath. Either he is or he isn't. He has to answer that question. It only behooves you to ask and get it on the record. You want him to take judicial notice of his contract with you, that oath. That oath is that he has taken an oath he has taken an oath to protect your rights in that courtroom with the penalty of treason. So he's not going to risk that for anybody. He's going to change up the way you get treated once you get the fact that he's on his oath on the record. Watch. He's going to treat you like a whole different person. Get a certified copy of the judge's bond and accept it for value. That is evidence of the limited liability the judge has in public when dealing with citizens and residents that are either owned or controlled by corporations. It does not limit the private liability that the man has when dealing with the people on the private side, since there is no money to pay you if you are damaged by the actions of the judge. You will have to be satisfied with possible payment to the straw man. But that is not the reason you are bringing the bond into this issue. The reason is to notify risk management, if necessary, that you have been damaged by one of its insured persons. This is not the bond for the man, but a bond for the judge. The man is doing business as a judge, for the public, as a public trustee, from time to time. He can also come under the private rules of equity, which is broadly defined as what is right. It is right for this man to recognize you as creditor, okay? But only if you perform like a creditor and avoid going into dishonor. If you dishonor anyone, you will fit the profile of the debtor. And he can ignore you, everything you do on the private side. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge. Not for a filing with the clerk. You don't give it to the clerk. You give it straight to the judge. Beware of the clerk. Mark the envelope private. Have a notary mail it by certified mail. Return receipt requested. And give you a certificate of service. Boom. The return address is the notary's address. Bam. That's an officer of the court. They cannot ignore that shit. The components of the letter are: you have accepted the presentment for value and returned it. You have exchanged your exemption for the discharge of the charge. You want settlement and closure. You are requesting an appearance bond at no cost to you. You are not disputing the facts. The parties have reached an agreement. There is no controversy, since they didn't respond. You have accepted the judge's oath and bond for value. Include a photocopy of the notary's certificate of non-response from your administrative process to confirm there is no controversy. Bam. File a notice of acceptance on the public side. This will let the public know that you are doing something on the private side to settle the account. If you do not give notice to the public, it will be assumed you're standing mute. This is a dishonor. It will result in a default judgment or summary judgment. What would this notice say? It is your intent to settle and close the accounting immediately. Bam! Who can get mad at you? Nobody. Trying to handle business and put into some of the shenanigans and nonsense. Wasting people's time and money. That's what those trusts are there for. It's for things like this. That's exactly what it's there for. Don't you dare pay one penny out of your pocket, when that's what that trust is there for. And the judge has access to it. So authorize him to act as your trustee and settle the matter. It is your intent to settle and close the accounting immediately. You have accepted and returned the presentment. You have exchanged your exemption for the discharge of the charges. You are requesting an appearance bond at no cost to you. You do not dispute the facts. You will enter a plea for the defendant. You want to be advised of the details of the hearing to receive the bond and enter the plea. That's what they want, is they want that plea. You are bringing the argument of the parties and the judge's oath and bond into the case. Public defender. If there is a court involved, the judge may appoint a public defender for the defendant. You are not the defendant. The straw man named on the presentment was chosen to be the defendant, okay? Now that's their choice. That's who they put there. Remember, rule number 1, the public and the private can never be mixed. They can't do it and you can't do it. They don't ever mix them, so be careful that you don't mix them too. If the defendant has a public defender, this is good. When the prosecutor signs the complaint, verifying it, which he better be verified. It should be signed and verified by the actual plaintiff. But at least better be verified by the attorney, even though he doesn't have firsthand knowledge of jack shit, so it really isn't valid. It doesn't count anyway. When the prosecutor signs the complaint, whether it should be sworn under oath, or should be sworn under penalty of perjury, that it is true, correct, and accurate. Okay. And his signature should be notarized as well. Otherwise, it's an unverified complaint. Get the fuck on. Okay. Now, when he does sign it, he's taken on the liability that may follow in the event that it is discovered the complaint is not valid. He has taken a chance, a big one, because at that point, he's the only attorney on record. Now, so he has filed a form of notice of appearance by filing the complaint or filing the grand jury indictment. He technically represents the defendant. Okay? Until someone takes his place. You hear what I said? So he is counting on someone appearing in the case to defend against his complaint. And now if that doesn't happen, he is the responsible party and liable for all the costs paid for in the complaint or associated with the statute violation. So now he has to pay all of the things that he was asking you to pay. He's not going to do it. He's going to dismiss the case. If that does happen, he is off the hook. Wait a minute. Okay. So he represents the defendant until someone takes his place. He is counting on someone to appear in the case to defend against his complaint. If that doesn't happen, he is the responsible party and liable for all the costs that he paid for in the complaint. If that does happen, he is off the hook. Almost 100% of the time, this is what happens. He is pretty safe taking this chance. Usually, the straw man named on the complaint gets a good attorney to defend him. That means the defense attorney has taken on liability, right? Not so fast. He does not take on the liability until he signs a notice of appearance and files it in the clerk's file for that case. Once he is the attorney of record for the defense, now he's on the hook. A. The prosecutor's name shall be endorsed on every indictment, and he shall be compelled to pay all costs and jail fees upon the acquittal or discharge of the person accused when 1. The grand jury, by its foreman, on returning no bill, expresses as its opinion that the prosecution was unfounded or malicious. 2. A jury on the trial of the prosecution finds it to be malicious. Or 3. The prosecution is abandoned before trial. When it is thus abandoned, the officer who issued the warrant shall enter a judgment against the prosecutor for all the costs and enforce it by an execution in the name of the state or by an attachment for contempt. Attorneys are instructed to bring their checkbook to every court appearance. This is why. B. A magistrate may, in his discretion, assess costs and jail fees against the person who instigated the prosecution when, at a committal hearing, the action is dismissed for want of probable cause. And the magistrate finds that the complaint was unfounded and malicious. This subsection shall not apply to law enforcement personnel. Great. Now he has to get someone to take his place. Okay? The likely taker on the position is the straw man, named in the complaint, indictment, or traffic ticket. The straw man can't talk, so someone has to represent it. Usually, that is you, because you have a point to make, or a lesson to teach, or testimony that will prove your case. Wrong choice. This is almost always the losing proposition. Really good, off-point paperwork has been put into court for decades with a very low success rate. The only way to win is to let the state win. I love win-win situations. How can you win and the state wins too at the same time? Huh? If you accept and return the presentment and exchange your exemption for the discharge of the charges, then the state gets the credit from your exemption and you get the discharge when you bond the case. That sounds easy, right? If the defense attorney can get you to act as the trustee for the straw man trust named on the complaint, then the defense attorney is off the hook too. Wow, it is just a series of passing the buck, a hot potato game. The one who ends up with it has to pay the bill. The prosecuting attorney starts with it. It goes to the defense attorney if he files a notice of appearance, and then on to the straw man. If you volunteer to defend, argue, testify, or join in the action in any way, it eventually ends up in your lap. You are stuck with the public liability unless you accept and discharge it from the private side. Are you starting to see what I'm talking about? Hot potato game, prosecuting attorney, defense attorney, straw man, you. If there is no defense attorney, it just passes to the defending straw man. If you accept, it stays with the prosecuting attorney. He has the power to settle the accounting if you authorize him to do so. That's all they want and need is your authorization. So give it to them. Get a copy of the court order for research purposes only, appointing the attorney, and accept it for value. Do this only if the judge appoints the public defender. Do not dishonor the court by refusing this privilege. The privilege is for the straw man, not you. You can accept his services offered by the court and instruct him on how he will handle the case. You can do this because you are the creditor through your acceptance. You are in honor. The court, the prosecuting attorney, the clerk, and the defense attorney are also still in honor. Prepare a letter of instruction to be mailed to the appointed defense attorney. Don't call him a defense attorney. There's nothing to defend. Nobody's defending anything. Okay. This letter to the attorney is your contract with him. See how simple it is? He got the letter, he got the contract. That's it. Do your job. Do as you are instructed, or you are fired. Kick rocks. You can fire an attorney at any time during the court case, as well you should if it's not working out. You can fire him right now. It's not going to hurt his feelings. Don't worry about that. They really don't mind. They don't care. It doesn't hurt their feelings at all. Now, if you do not establish the terms of your contract with him, the presumption will be that he's a defense attorney and he's defending the defendant as an officer of the court. Get a certified copy of the letter to the lawyer from the notary before it is mailed to the lawyer. If time is crucial, fax it to the lawyer with a notation that it is also being mailed by certified mail. Return receipt requested. Have the notary mail it, certified mail, return receipt requested, and give you a certificate of service. What should this letter say? You are claiming an interest in the subject matter of this case, an intervening interest. Your property rights may not be protected by the existing parties. The straw man is your property, okay? And your body is your property too. You are accepting the public defender's appointment offer and returning it. You are requesting that the public defender put his bar card away during this case. I don't know if you will, but you can request it. You are requesting that the public defender act as your counsel instead of acting as an attorney. Yes, he can do that. Yes, you're allowed to have counsel. It doesn't have to be an attorney. There is no controversy over the facts, so you don't need an attorney. You have an attorney if there's a dispute. We don't have one. He is not authorized to defend the defendant. You are asking that he read this entire letter into the record in open court. It's not that hard. It's not that much to ask of him. He's going to kick and shuffle. But hey, do your job. Do your job, douche. They get paid to do this shit. You're asking that he read this entire letter into the record in open court and file it with the clerk afterwards in open court. That's the best way to get something into the record. You hand it to the bailiff to hand it to the clerk and the judge. You already have an agreement of the parties, remember? Show your copy of your certificate of non-response. You are asking him to check the clerk's file for a bond and bond the charges. Get to work, douche. Go do your job. I want to post a bond to the case. You've heard of that, right? Okay, get it done. You are not disputing the facts. You want the prosecuting attorney to write the check to close the account. You will accept the prosecuting attorney's bond to bond the charges if he wants to go that way. You will start bankruptcy proceedings if necessary to locate your remedy. That means through him and through his pocket. You want settlement and closure. Now, they can't get mad at you for wanting settlement and closure, now can they? You're trying to take responsibility for this shit and get it dealt with. No more kangaroo court, please. No more bullshit shenanigans. Just, can we get down to business? Thank you. You are not disputing the facts. You want the prosecuting attorney to write the check to close the account. You will accept the prosecuting attorney's bond to bond the charges, and you'll start the bankruptcy proceedings if necessary. You need to let them know that. Show your teeth a little bit. Let them know you mean business, because that's the part that they don't want. So let them know you're willing to do that and that you understand, because unless they understand that you mean to enforce your paperwork on them, they're not going to give two fucks about it. You have to let them know that you know how to enforce it and that you're ready to do so. And that's the way you would enforce it with the prosecutor, is you would do a bankruptcy proceeding on him. He definitely doesn't want that. So let him know that you understand that and you're willing to go there if necessary. Okay. You may require the defense attorney to file a notice of appearance in the case. You want settlement and closure. Get that through his mind. Check the clerk's file for a bond. There has to be a bond in every case. In the event that the complaint is an absolute fraud and sham. Okay? And plenty of false claims being filed every day. The presumption is that the prosecuting attorney's bar number is bonding the case. This is okay. But there is no written evidence of a bond in the file. Okay? So Just because his bar card doesn't bond the case, okay? Just because he has a bar card doesn't bond the case. No, it doesn't. If there is no written bond, then you can bond the case. Cool. Perfect. They're counting on you not knowing about this. The presumed attorney's bond is superseded by a written and signed bond. Right. The fake one that they say he has, which he doesn't, because you can see it's not there, your actual bond will override his fake one that doesn't exist somewhere up in his bar card. That's not a bond, dude. That's his bad. That's the choice he takes, the choice he makes with the way he conducts business every day. And it usually works like a charm, but not with everybody, okay? Not every time, dude. No. He's going to be hot, though. Be ready for it. Be ready for it. He's going to be hot. Stay calm. But don't let them be rude to you. Anytime they're rude to you, that's just, you don't have to take that shit. You could get it thrown out because of that. A predated bond might just show up in the file later to try to minimize the effect of your bond, but you can still bond the case. The bond falls into the category of a replevin bond. It is not a replevin bond because they were used in common law before the court systems were integrated. Now it has to be a bond that is in the nature of a replevin bond, that is used as a replevin bond was formerly used. 14. Prepare your bond to bond the case. This is the bond that completes the accounting for the court. This is the money, honey. This is what they wanted in the first place. It has the charge on the books, but it does not have the offsetting bookkeeping entry. The missing bond is what has the books out of balance. When you put your bond into the case file, by filing it with the clerk of the court, it balances the books. Thank you very much. Attach a photocopy of the docket sheet to your bond to verify the lack of a bond in the case. Bam! They can't say anything else about it. I do not know why it is not notarized, but my guess is that it is coming from the private side and not the public side. Right, you don't have to notarize your bond, no. If you have a notary notarize your signature, you might be mixing public and private, so don't do it. If there is no defense attorney, the certificate of non-response. This is how you enforce your paperwork with people. Regarding acceptance by John Henry Doe of complaint on case number such and such. John H. Doe. Susan Smith, I'm the notary who verified Dave Brown's dishonor of John Henry Doe's notice of acceptance for John H. Doe, pursuant to state law regarding evidence of dishonor, OCGA 113505 and 111202. I certify the following. The record shows I mailed a notice of breach to Dave Brown at ABC Agency at such and such address by certified mail package number as verified by certificate of service. After acceptance of both mailings, Dave Brown for ABC Agency refused to send the confirmation that this account for the case number has been adjusted and settled, nor a notice of dishonor from a qualified third party excusing his refusal in the 10 days following the second mailing. Dave Brown for ABC Agency did not cure his dishonor. He gave no reason for his refusal to confirm the adjustment and settlement of the account or send a notice of dishonor. Therefore, based on the foregoing facts, I certify that Dave Brown for ABC Agency dishonored John Henry Doe and me through his non-response, and did thereby agree that John Henry Doe accepted the subject complaint for case number such and such, returned the complaint, exchanged his exemption for the discharge of the associated charges, presented an authorization for the use of his credit to set off all associated court charges, included processing instructions, included a statement of account showing a zero balance, sent a letter of credit to Timothy Geithner as notice that exemption number such and such was being used to settle account number, case number such and such. Bam. That's it in a nutshell right there. Further, Dave Brown agrees that his refusal to send the written confirmation of the settlement of the account, I mean, what does he get paid for? To do business or not? Or a notice of dishonor from a qualified third party in no way negates the fact that said account is settled and closed. He didn't like the form of payment. Oh well. That he and the agency he represents have no capacity to pursue collection on said account. Got that? And that further pursuit of collection is agreement that Dave Brown and his agency owe me $5,000 every time they're going to try to collect from here on moving forward. Dated, notary, signed and sealed. Oh, it's always nice to add in void where prohibited by law, just in case. Administrative process, certified mail number. I always put this as a certified document. Mailed by Susan Smith, Notary Public, to Dave Brown, notice to agent is notice to principal is notice to agent. Regarding the complaint on case number such and such, notice of acceptance. Please be advised, I have accepted your presentment to John H. Doe for assessed value. It's okay if you don't know the amount to put there. They do. So that works. Assessed value. And the associated accounts. Use that terminology there. And there's plenty of associated accounts. So they're going to be happy to get those paid for as well. Okay, please be advised. I've accepted your presentment to the all caps for the assessed value for however much you say it is, and I'm returning it to you in exchange for closure and settlement to account number, case, and you put the case number there. Bam, I want this case number settled, done with. Please send the confirmation that the account for case number such and such has been adjusted and settled. I just sent you the money, douche. Do your job. What? Is there something else that needs to be done? No. To the address shown above, or send a notice of dishonor from a qualified third party. Now, that's what he needs to do. I'm also enclosing an authorization for you to facilitate the use of my credit to discharge all the court charges that may apply. Okay? Thank me. I'm welcome. The instructions and statement of account are attached for your convenience. Now get to work. John Snow is also being notified that I'm using my credit for this purpose. Your refusal to send the confirmation, I paid you the money, can you send me the receipt? You can't even do that? Okay. Or notice of dishonor will in no way negate the settlement. You've been told. And will be your agreement that you and your agency have no capacity to pursue collection moving forward. And for the collection efforts from your agency, you already agreed that you're going to owe $5,000 for each one. And the John H. Doe Trust may take, that means may take all necessary steps to secure its claims to the debt owed to it and to collect. In other words, yes, I can get the $5,000 if you continue to pursue it, and I will get it. Thank you for your immediate attention to this matter. You have to let people know what you're willing to do, okay? Or they're not going to take you seriously. They don't think you know what you're doing. They don't think you know how to enforce it. That's what it is. You might know a couple things, you might have figured out a couple things, but they count on the fact that you're not going to know how to enforce anything, even if you do figure out a couple things here and there. So you need to let them know that you do know how to enforce it and that you're willing to do so. And that usually is enough. Thank you for your immediate attention to this matter. Sincerely, John Henry Doe. Here's another example. Certificate of service, mailed to, name of respondent, address. The papers identified as notice of acceptance, accepted presentment. By mailing them in a prepaid envelope, addressed to the recipient named above, bearing certified mail number such and such, 9898. That's the 4 digits after the zip. Return receipt requested. Dated, Notary Public, my commission expires. Seal. Another notice of non-response sample. Mailed by Susan Smith, Notary Public. Certified mail to Dave Brown. Notice to agent is notice to principal. Notice to principal is notice to agents. Regarding the complaint on case number such and such, John H. Doe. On such and such date, I sent you a notice of acceptance and a request that you send confirmation that the account number for case number such and such has been adjusted and settled, or send a notice of dishonor from a qualified third party. It was sent by certified mail with return receipt requested with certificate of service. In the event your dishonor through non-performance and non-response was unintentional or due to reasonable neglect or impossibility, I am attaching a copy of the same presentment to this notice of non-response to give you another chance. Please send confirmation that the account for case number such and such has been adjusted. Now that's all I'm asking you to do, is take the money and send me a confirmation. Is that so much to ask? Are you doing business or not? Ridiculousness. They're going to act like, oh, you're dumb. They're going to act like you're good. They're going to try and knock you off your square. They definitely will pretend they don't know what you're talking about. Okay, about a lot of things. Don't let that faze you. They're going to try to make you feel like you're dumb and you're stupid. Okay? That's what they'll do. So just let it roll off. You have to ask for everything at least 3 times. If you have an excuse for not performing as requested, which it wasn't very much to ask, please mail your particular statement to me at the address noted above. Your specific performance or statement is expected no later than 10 days from the date this notice is postmarked. We're all adults here. This is not children involved, okay? Handle your business, bro. Thank you for your prompt attention to this matter. If you fail to cure the breach, your refusal will be your agreement to all the statements made in the notice of acceptance. And that means you agreed to it, everything you've been told. Seal, Notary Public. Court process, notice of acceptance to the judge. And I've used these examples for my own paperwork in my own court cases, and they worked flawlessly. And I kept my documents short to a 1-page document whenever possible, as much as possible. Sometimes it had to go over 1 page and a half or something, but it's awesome to try and just get it all in one page if you can. Okay, this is a court process. Oh, the notice of acceptance to the judge. Okay, regarding complaint number such and such. Dear Judge, please take notice that I have accepted the presentment made by the prosecuting attorney to the all caps for assessed value and returned it to the presenter in exchange for closure and settlement of account number such and such. You need to let the judge know that you paid the bill. He'll be glad to hear it. I have exchanged my exemption for a discharge of the charges. Bam! There's no questions to be asked about it or conversation to be had. This is what I have done for you. Thank me, I'm welcome. I enclosed an authorization for him to use my credit to discharge all the court charges that may apply. Thank me, I'm welcome. The instructions and a statement of account were attached. The Treasury has also been notified that I'm using my credit for this purpose. I request an appearance bond at no cost to me, so I can enter a plea for the defendant. Now see, that's what they want, is they want to get that plea. So you're offering them what they want, and that's a wise thing to do. Since you're acting as creditor, you've already paid for everything, all the charges up front, then of course you can request an appearance bond at no cost to you, since you're acting like the creditor who's going to back to take care of everything. It's all good. I request an appearance bond at no cost to me, so I can enter a plea for the defendant. See, you're giving them what they want right there. They want that plea because that gives them jurisdiction, and then they can take the money. Do not dispute. Oh, I do not dispute any of the facts. Based on the issuance of the appearance bond, assume that you will get it, and you will, and the absence of an assessment and findings of fact and conclusions of law. We're not going there. I will enter a plea for the defendant, and that's what they want, so give it to them. Exchanging my exemption for full settlement of the account, both civil and criminal. So bam, I'm not going to plead, I'm not giving you the plea that you want so much unless it's for the whole enchilada. I'm entering the plea of guilty, and I'm exchanging my exemption for full settlement of the account. Now that's the only way that I'm willing to enter a plea for the defendant. Is if I'm here to settle it. I'm not going to play around, okay? I will enter a plea of guilty, and I will pay for it, and that's over. Leave me alone now. Okay. So I will enter a plea for the defendant, exchanging my exemption for full settlement of the account, both civil and criminal. Thank me, I'm welcome. I have requested that I be notified through the notary named above, with the place, the time, and the date that I should appear to receive the appearance bond. I expect that will also be when I will enter the plea for the defendant into the record. It's brilliant. You're giving them what they want. They can't say no because you're giving them what they want. As much as they might like to say no, they can't. They don't want to. Okay. The opposing parties have previously reached an agreement on the issues in the complaint. There is no controversy at all. It's so beautiful because if there's no controversy, then there's no freaking judge or court needed to get involved at all. The court and the judge don't have anything to say about anything because there's no dispute. We have an agreement of the parties, Judge. We worked it out ourselves. And that means you guys take jurisdiction over your own business, and the court and the judge have nothing to do with it. It's beautiful, beautiful thing. Let the court know there's a meeting of the minds. There is no dispute. The opposing parties have previously reached an agreement on the issues in the complaint. There is no controversy. A copy of the relevant certificate is attached. I want settlement and closure of this account immediately. No more shenanigans, guys. Sincerely, the living man. It's brilliant. Court process. Notice of the court clerk. Okay, so you're going to want to give a notice to the clerk of your acceptance and private process, because the clerk is the money. The clerk, what does the clerk do? The clerk takes the money. The judge looks over at the clerk to make sure if something's okay or not, and the clerk will let him know, hey, did we get his money? The clerk will let him know, yes we did, or no we didn't. Yes it's okay, or no it's not okay. So if you're paying for the charges, then you definitely need to let the clerk know. Okay, so let's look at this example. Notice to the clerk of acceptance and private process. This is for research purposes only, for the purposes of doing more research. I don't give legal advice to anyone, please be advised. So, notice of acceptance and request for appearance bond. Okay? Please be advised, it is my intent to expedite this process to reach settlement and closure on this accounting immediately. They must have to be happy to hear that. You're not one of these people who's going to drag something out for 3 years just to make their lives miserable. No. You're there to expedite the process so they can go play golf. Okay? They're going to like you a bunch. You're their kind of guy. Now, I've accepted the complaint for case number such and such and for value and returned it to Mr. So-and-so, who appears to be the charging party on behalf of the state of California or whatever. I have exchanged my exemption, number such and such, no dashes, for the discharge of the charges. I hereby request an appearance bond at no cost to me, since you just paid for the whole shebang. There's no reason why you shouldn't have it. So I can enter a plea for the defendant, which is what they want. It's brilliant. I hereby request an appearance bond at no cost to me so I can enter a plea for the defendant. I do not dispute the facts. They're like, good. Save us some time and trouble. Hearing all these stupid cases all day long. Based upon the issuance of the appearance bond and the absence of an assessment of and findings of fact and conclusions of law, we're not going to plead the case. I will plead guilty to the charges and exchange my exemption for full settlement of the account. Bam. Thank me, I'm welcome. Both civil and criminal. How many people go in there and say that to them? Hey, I'm here to pay for everything. Great. Step right up. We've been waiting for you. Please notify me at the address shown above with the place, the time, and the date that I should appear to receive the appearance bond. I expect that will also be when I will enter the plea into the record. Boom, you're going to get something and they're going to get something. It's win-win. Those are some advanced strategies. I have attached a copy of the certificate relevant to the existing agreement and copies of the judge's oaths of office and bond. I have retained the originals for introduction in open court. Submitted this day of 2012. Name, a copy of the foregoing was mailed on the such and such day to such and such attorney for the plaintiff. Okay. Court process, letter to the counselor, another sample. Greta Jones, counselor, from Mr. John Henry Doe, the living man, regarding case number such and such. Please take note that I am claiming an interest relating to the property which is the subject of this action. I am so situated that the disposition of the action may, as a practical matter, impair or impede my ability to protect that interest, which is not adequately represented by existing parties. I accept the kind order of the United States Court on such and such date by John Black to appoint you attorney for the defendant. I accept this offer for value on behalf of the defendant, and I'm returning it with this notice to you. I now request that you escrow your bar certificate during the course of this case and serve as my counsel in the following manner. And only in the following manner. And I guess, yes, they are going to have to put that bar card aside for the moment to do that, because they can't, I don't think they're allowed to act and do those things under the bar card. Anyway, so, hey, they're going to be off the hook. It's not under the bar card, okay? So you can't get in trouble for doing it, so be quiet about it. Yes, I know you're an officer of the court, but right now you're just going to act as my counsel. Can you do that? Can you just act as my counsel? You don't have to be under the bar card, so you can't get in trouble for a douche. Calm down. Do your job. You were appointed to do the job. Let's get it done. No more shenanigans. I accept this offer for value. I'm returning it with this notice to you. I now request that you escrow your bar certificate during the course of this case and serve as my counsel in the following manner and only in the following manner. Otherwise, kick rocks. As there is no controversy in this matter, don't make one where there isn't one now. Okay? I do not want you to argue any facts or public issues as they apply to the defendant. You are not authorized to foster an argument or to join an argument on my behalf or on behalf of the defendant. You are not authorized to defend the defendant. For you to stay in honor, I want you to enter the notice into the record by filing it with the clerk of the court and reading it into the record in open court. Now, is that so hard for you to do? Okay, grow up now. This is time for you to put your big boy pants on and read the letter into open court. It's not that big of a deal, and it's not ridiculous at all. It is my instructions. Take it or leave it. This is notice that I have accepted for value and returned all public offers associated with this matter. And notice that I have made every effort to reach settlement through exchange of my exemption for adjustment and set-off of the public charges against the defendant. Ask the judge to take mandatory judicial notice of the private agreement that has been reached through offer and acceptance. A copy of the relevant certificate is attached. I want you to get a copy of the bond that bonds the charges in this matter. Oh, there isn't one? Oh, well, what a surprise. Well, if there is no bond in the file, then I will provide my bond instead. Okay? You got that? Okay. It's not that hard for him to understand. Don't let him treat you like you're dumb. Okay? Does he understand English? Okay, let's get it done. Notice of acceptance of offer. Return of offer and instructions. 4. I want you to request an appearance bond at no cost to me, so I can be released on my own recognizance. When the bond has been issued, then I will enter a plea of guilty to the facts for the defendant. I will not dispute any of the facts in this matter, but I do not agree to be held personally liable with no protection. I am not the defendant. After acquiring, I'm not the trustee. Okay? Make sure they know you don't agree to be the surety. Hey, I do not agree to be the surety in any court case. Make sure to get that on the record. Let them, hey, but I do not agree to be held personally liable. Okay? With no protection. I do not agree to be the surety in any court case. After acquiring the appearance bond, then I authorize you to use my exemption to bring the accounting of this matter to closure. Request that the prosecuting attorney write a check to close the account and release the bond to the defendant and tell him to do his job. He started this mess. Now he needs to finish it. If for some reason my request for an appearance bond is dishonored, I want you to give notice of my intent to accept John Brown's bond, the prosecuting attorney, and to use it to bond the charges, using his bond as the surety. His signature is the only one on record as a responsible party. So that's a very real threat. That's not just blowing smoke. That is what will happen, and he knows it. It's got 3 days. Something's going to happen. If necessary, I also want you to give notice of my intent to accept John Brown's bond for value and to use it to charge a Chapter 7 involuntary liquidation and start discovery under 11 U.S.C. 1126B. If the dishonor is not cured within 72 hours, I want you to file the bankruptcy petition in the Federal Bankruptcy Court naming the defendant as the debtor and John Brown as a delinquent creditor, along with others who have already or may dishonor me in the process. You are authorized to distribute B10 proof of claim forms to the dishonoring parties, should there be any at the next hearing. This bankruptcy discovery process will locate my remedy just fine and release it to me through liquidation of the delinquent creditor's assets. Okay? Tell the prosecuting attorney he's going to have to go sell his Porsche, okay, to pay me if he doesn't handle this properly. In the event that you, as my fiduciary, dishonor me by not following my instructions, then you could go kick rocks. Then I request that you file a mandatory judicial notice of your refusal with the court and file a written appearance in this case. Stop playing dumb. You guys can fool most of the people most of the time, but you cannot fool all of the people all of the time. Doesn't work that way. That's okay. Thank you for your understanding and cooperation. Bam, be polite. It's just business, it's not personal. Notice of appearance of offer, return of offer, and instructions. Bond the case, sample number 8. Okay. Here we go. Here is what you will write on your bond. Okay? The name and address of the living man. The Superior Court in and for the county of whatever county and state, or United States of America, case number such and such. There appearing no bond of record, to initiate the matter regarding case number such and such, and or warrant number such and such, if applicable, and associated accounts. Don't forget that, because there's a bunch of associated accounts. They're going to be happy to get those paid too. John Doe Smith, I, John Doe Smith, the living man, undertake as follows. In consideration of the fact that no lawful money of account exists in circulation, and in consideration of the fact that I have suffered dishonor regarding the matter of case number such and such, and warrant number such and such, and associated accounts, I underwrite with my private exemption, number such and such, no dashes, any and all obligations of performance, loss, costs, fees, fines, whatever, sustained by the United States of America or the state of California and the respectful citizens regarding said matter. You are going to make sure nobody gets harmed over this bullshit. Okay? Done at the county and state on this date. John Henry Doe, the living man. Now, do you see how simple that is? That is a one-page document. That's 3 of the shortest paragraphs I've ever seen, ever, in a legal document. Boom. Your word is your bond if you are acting as the creditor. They don't have time to trust in any debtor, okay? They don't even want to hear, they're not even going to consider trusting in any debtor. The debtor always loses, period. That's the way the system is set up. Creditor always wins, debtor always loses. Game over, twats. Okay. Another sample to bond the case. Jurisdiction and venue. Jurisdiction in this matter is hereby granted by John Henry Doe, authorized representative for the all caps, by way of sufficiency of pleadings. See affidavit in support of amended complaint. 2. The venue of this court is correct, as the all caps does business in the state of California. And the living man is diverse from ABC agency doing business in the state of, and the amount in controversy exceeds $75,000. Parties, the all caps, has established a residency in the state of California for over 1 year. 4. ABC agency demonstrates appeals in the jurisdiction of the United States and does business in the state of California. The plaintiff has exhausted administrative remedy and comes to this court of equity with clean hands and in good faith. It's more than I can say for the other side. A lot more. The plaintiff has established, because you're the plaintiff now, since you bonded the case. Now you're the plaintiff, you're the creditor. You're not the defendant, you're not the debtor. Now they are. Hey, that's their bad. That they didn't bond the case. They should have put their money where their mouth is when they tried to come after you in the first place. But that's just how they do business all day long. Okay, and that's great. Good for them, okay? But not every time. Not every time. Not everyone is going to just lay down for them. Almost everyone, but not everyone. And for those few out there who don't just lie down, I love you and I respect you 100%. Those are my favorite kind of people. The ones that don't just automatically bow down to whatever false authority figure comes their way. Okay, so the plaintiff has exhausted administrative remedy. Okay, I gave him a chance and he didn't respond, so he's done. He's in default. The plaintiff has established judgment in estoppel against the defendant as evidenced by the attached certificate of non-response certified by the notary public for that county. The plaintiff's administrative remedy is res judicata. That means it's done, douche. It's done. Failure of defendant to respond in this matter is stare decisis. That means it's over once and for all. The plaintiff's administrative remedy is ripe for judicial review, and there are no facts in controversy. Bam! Then the court has nothing they can do with it. Period. They're there to settle disputes. Now there isn't one, so kick rocks. Okay, legal claims. Plaintiff is entitled to relief in this equitable claim. The defendant is stopped for failure to respond to original administrative process. He had his chance, so he didn't have anything to frickin' say, or he would have said it. The plaintiff has placed the facts and law before this honorable court. Plaintiff requests judicial review of his administrative process and remedy. They have to give you a remedy in every situation, okay? You create your own remedy. Yes, you can create your own remedy as well. You should. You're going to have to. No one's going to hand you one. You're going to have to figure one out for yourself. But they have to let you have one. Do you understand? But they don't have to give it to you if you don't. You have to create it for yourself, your own remedy, and that's okay. These are creative problem-solving methods, and these are very advanced strategies. The plaintiff requests this court to find the facts and execute on the law of the contract before this court, because the new paperwork is the contract. Plaintiff requests summary judgment on his administrative remedy. Bam, douche, we don't have to go to court over this one. Plaintiff requests the court to order the defendant to pay the sum certain of 1 million, however many it is, over to the plaintiff. Plaintiff requests the court to release the order of the court to the all caps, respectfully submitted by order of the all caps, by the authorized representative, the living man. Okay? Who is the authorized representative of the all caps. Bam, it's beautiful and it's simple, and it's important to distinguish yourself from the all caps. No, I'm the authorized representative of the all caps. It's a big difference, dude. Okay? It's a huge difference. Don't get it twisted by any means. Don't let them get it twisted. Don't let them. And have it notarized. Bam. Certificate of service. Okay. 1. Bond supporting credit authorization. 2. Bond for discharge. 3. Appearance bond. 4. Surety bond. 5. Case bond. 6. Performance bond. Rules of the game. Rule number 1. The fiction and the real cannot mix. The public and the private cannot mix. A living soul cannot interact with a dead entity, a corporation. It's a fiction. It doesn't actually exist. It's just an entity, a legal entity, which cannot talk, and it doesn't have hands, so it can't do sign language. Okay? It's a fiction. It doesn't exist in reality. Not when you compare that to the living man or woman. So a corporation can never sue the living man or living woman because the living woman and living man have status over any and all corporations, because something alive obviously has rights and everything else, whereas something that's dead has nothing in reality. It's just playtime. It's just acting. So, rule number 2, stay in honor at all costs. Rule number 3, there is no money. We've skipped a number here, but the next rule is do not participate in public plays. Oh, okay, he's not a math teacher. All right, it all has to do with trusts. Here is an example of a typical court scenario when the man participates. Here is a different scenario when the man does not participate. Okay, administrative process. Step 1. Visualize this first. You are in the courtroom on your case. Step 2. Prepare the certificate of non-response. It's everything. Step 3. Prepare your notice of acceptance. Step 4. Prepare the notice of non-response for the notary. 4. Accept and return the court presentment. 5. Attach an asset, an authorization for the state to use your credit. 6. A letter of credit. 7. Get a certified copy of the judge's oath of office and accept it for value. 8. Get a certified copy of the judge's bond and accept it for value. Oh, you'll be sitting pretty if you do. 9. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge. You don't send the bond to the clerk. You send it straight to the judge. 10. File a notice of acceptance on the public side. Public defender, hot potato game. 11. Get a copy of the court order appointing the attorney and accept it for value. 12. Prepare a letter of instruction to be mailed to the appointed attorney. 13. Check the clerk's file for a bond. 14. Prepare your bond to bond the case. 15. Remove the case if necessary. Sit back and observe the play. Do not participate in the courtroom drama. That's it. We'll read again after your updates. This was Creditors and Their Bonds, plus the hidden commercial court process. This is Kristen at Clarity Now.